The shocking return of Alex Murdaugh inside the courtroom on June 29, 2026. On June 29, 2026, Alex Murdaugh walked back into a South Carolina courtroom for the first time since his murder convictions were overturned. Nearly everyone in the room understood that this wasn't just another routine hearing. It marked the beginning of a brand new chapter in one of America's most controversial murder cases. A man once convicted of brutally killing his wife and son was now preparing to face another jury. But before that could happen, the court had to decide how the next trial would move forward. Alex Murdaugh entered the courtroom wearing an orange prison jumpsuit with shackles on his wrists and ankles. Although his murder convictions had been thrown out by the South Carolina Supreme Court, he was far from a free man. He remains behind bars because of dozens of financial crime convictions that resulted in state and federal prison sentences totaling decades. Regardless of what happens in the murder retrial, Murdaugh is expected to remain incarcerated for years. The hearing was held before Circuit Court Judge Deborah McCaslin in Lexington County. Unlike the emotional and dramatic murder trial that captured worldwide attention in 2023, this hearing focused on legal planning. There were no witnesses, no emotional testimony, no crime scene evidence shown to the court. Instead, both sides came prepared to discuss how the retrial would proceed after the Supreme Court's decision. The biggest announcement came when Judge McCaslin officially set the new trial date. Alex Murdaugh will face a second murder trial beginning on April 5, 2027. That date now becomes one of the most anticipated moments in recent American criminal justice history. It means prosecutors will once again attempt to convince a jury that Murdaugh murdered his wife, Maggie Murdaugh, and their youngest son, Paul Murdaugh, at the family's Moselle hunting estate in June 2021. The retrial became necessary after the South Carolina Supreme Court overturned Murdaugh's 2023 convictions. The court ruled that former Culleton County Clerk of Court Becky Hill engaged in improper conduct involving jurors during the original trial. According to the ruling, her actions created an unacceptable risk that the jury's decision may have been influenced. Importantly, the Supreme Court did not say Alex Murdaugh was innocent. It also did not say prosecutors lacked evidence. Instead, the justices concluded that every defendant deserves a fair trial before an unbiased jury, and they determined that standard had been compromised. As the hearing continued, Murdaugh's attorneys, Dick Harpootlian and Jim Griffin, presented several requests they believe are necessary before another trial can begin. One of their biggest requests involved moving the trial away from Culleton County. The defense argued that years of non-stop media coverage have made it almost impossible to find impartial jurors in the community where the murders occurred. Since 2021, the case has dominated television news, podcasts, documentaries, newspapers, YouTube channels, and social media. According to the defense, nearly everyone in Culleton County has already formed an opinion about Alex Murdaugh's guilt or innocence. Defense attorneys argued that selecting a truly fair jury under those circumstances would be extremely difficult. They asked Judge McCaslin to move the retrial to another county where potential jurors may have had less exposure to the case. Prosecutors opposed the request, maintaining that a fair jury can still be selected through careful questioning during jury selection. Judge McCaslin did not immediately rule on the request, leaving the issue to be decided during future hearings. The defense also focused on forensic evidence that has been discussed for years. Specifically, they requested independent testing of DNA recovered from beneath Maggie Murdaugh's fingernails. Their attorneys argued that advances in forensic science and independent laboratory analysis could produce additional information that may help clarify what happened on the night of the murders. Rather than relying solely on previous testing, they want outside experts to conduct their own examination of the biological evidence. The prosecution did not agree that additional testing was necessary, but the court did not make an immediate decision. Instead, the matter remains one of several issues that will be addressed before the retrial begins. Another request involved technology. Because Alex Murdaugh remains incarcerated, his attorneys argued that he needs better access to the enormous amount of evidence collected in the case. They asked the judge to allow him to use an internet-disabled laptop inside prison. According to the defense, the case includes thousands of pages of reports, interviews, photographs, phone records, financial documents, surveillance videos, forensic reports, and digital files. Reviewing such a massive amount of information using only paper copies would be extremely difficult and time-consuming. The defense insisted that allowing Murdaugh to review digital evidence would help him actively participate in preparing his defense. Judge McCaslin indicated that this issue would require coordination with correctional officials before a final decision could be made. Throughout the hearing, prosecutors made it clear they remained fully committed to retrying the case. Lead prosecutor Creighton Waters told the court that the state intends to move forward aggressively. Waters successfully prosecuted Murdaugh during the original trial, and despite the convictions being overturned, prosecutors continue to express confidence in the evidence they have collected. The state emphasized that the Supreme Court's ruling focused entirely on jury misconduct allegations involving Becky Hill and did not question the strength of the prosecution's evidence. Prosecutors believe that when the evidence is presented again before a properly selected jury, it will once again support a guilty verdict. Although the hearing attracted significant public attention, viewers expecting dramatic courtroom confrontations were unlikely to find them. There were no emotional family members taking the witness stand. No forensic experts explained crime scene evidence. No police investigators testified about the investigation. Instead, the hearing served as an organizational step that officially launched preparations for one of the most closely watched retrials in America. Legal experts continue to debate how the second trial may differ from the first. Prosecutors now know exactly how the defense challenged their evidence during the original proceedings. Likewise, the defense has had years to examine every piece of evidence collected during the investigation. Both sides will likely refine their strategies before the retrial begins. One of the most important questions still facing the court is where the retrial will actually take place. If Judge McCaslin grants the defense's request for a change of venue, jurors would be selected from a completely different county. If the request is denied, jury selection would likely remain in Culloden County, where the murders occurred and where public interest remains especially high. Meanwhile, the DNA testing request could also become significant depending on what additional analysis reveals. Although no one knows whether new testing would uncover different results, both sides understand that even small forensic developments can influence a jury's understanding of a case. For Alex Murdaugh, the June 29 hearing represented another extraordinary turn in a legal saga that has captivated the nation for years. Once a respected attorney from one of South Carolina's most influential legal families, he now sits in prison while preparing to defend himself against murder charges for a second time. The road ahead remains uncertain, but one thing is now clear. Unless future rulings change the schedule, Alex Murdaugh will return to court on April 5, 2027, where 12 new jurors will once again hear the evidence surrounding the deaths of Maggie and Paul Murdaugh. As both the prosecution and the defense continue preparing for that day, millions of people across the country will be watching closely. The questions surrounding this case are far from over, and the next trial may become just as historic as the first. Whether the outcome ultimately confirms the original verdict or reaches a different conclusion, the June 29, 2026 hearing marked the official beginning of the next chapter in one of the most closely followed true crime cases in modern American history. Don't forget to like the video, subscribe to the channel, and turn on notifications for more true crime stories. Thanks for watching, and I'll see you in the next case.